Good afternoon, everyone. Welcome to today's web seminar. We're going to be talking about professional liability insurance, what it is, how important it is, and why you need it. And today's session is brought to us by Lawyer Cover, and we thank them very much for that. And before we start, I want to take a moment to talk about the technology that we're using. On the right-hand side of your screen, you should see a control panel. You can use that control panel to submit a question to us via chat at any time during today's webinar. Just type your question into the box and click send. And then we'll queue your questions up and get to as many as we have time for at the end of today's session. And now I'd like to turn the floor over to Brian DeGraw from Lawyer Cover.
Thanks, Mike. Once again, I'd like to thank Lawyer Cover for sponsoring the webinar. Our focus is going to be, as you can see, on professional liability insurance. Thank you for all attending and participating. So let's get started. What we're going to review today is some background information on what professional liability is. We're going to talk about why you need it, how the process works. The goal of the whole webinar is to put you in the best possible position to qualify for competitive pricing and the best coverage available in the marketplace. So I'll hope to give you a roadmap to succeed in doing that. I'll also provide you with some claims examples to get a better sense of what we've seen after over a quarter century in handling professional liability claims for law firms. More importantly, I'm going to provide you with some tips for reducing claims, what to consider before you purchase professional liability insurance, and then as Mike indicated, we'll take some questions and I'll provide some answers at the end. So let's get into the first part. What's in the name? From a professional liability standpoint, as you can see, this is pretty basic, but bottom line is, as a lawyer, it means that you're professionally engaged in providing legal services to your clients. I know it's obvious, but we want to provide kind of an overview of what the professional term means. It's a legal term, a legal definition, and it's important to be aware of it as you provide services, that you have some responsibility to your clients. Ultimately, you could be held liable to your clients in providing professional services to them. So what does liable mean? Well, obviously, liable means to be responsible to your clients. Not only do you have a moral and ethical responsibility to your clients in providing them with services, in some cases, and we'll talk a little bit further about this in a few minutes, you may have a fiduciary liability to your clients. So where does this put us? Well, we talked about now the fact that you're providing professional services to your clients, even if you don't do something wrong, which is where we tend to think about purchasing insurance, less so about what if we didn't do anything wrong, can we still be sued? Well, sure you can, and we'll talk a little bit further about that. And what type of protection is available in the event that you are sued, even if you did nothing wrong? Well, first of all, let's examine what this could potentially affect if you are sued or brought into a lawsuit. The first thing to examine is, and most importantly, you have a professional reputation. This is the lifeblood to providing for yourself and your family, and it's important to protect that. That's what the insurance policy is all about. You could potentially also have business disruption, both personally and to your practice in the event of a lawsuit. So your reputation and a potential disruption to your business are key reasons why you have to be aware of the availability of professional liability and why you should consider purchasing it if you haven't already. So let's talk about professional liability insurance. For some of you, you're fully aware of it, but it's important to start with the basics of the professional liability policy. Not only is it there to defend you in the event that you are sued for some type of act, error, or mistake, or some form of negligence or misrepresentation, but it will indemnify you for any type of covered claim. This is important to be aware of because next we're going to talk a little bit about how your professional liability insurance is different from your general liability. In many cases, there's some confusion about, well, I have a general liability policy. Doesn't that provide the protection in the event that I'm sued for making some type of mistake? So let's first talk about what your general liability policy covers. And typically, this is the first policy purchased when you start your practice or you begin to provide some type of service to your clients. Your general liability insurance policy is there to provide coverage in the event there is some physical injury to a third person. It can't be an employee. That would be a workers' compensation claim. But an example of what a general liability insurance policy would respond to is simply you have a client meeting, client is visiting with you in your office, and somehow they get hurt. There's a physical injury. That's the intent of the general liability policy. There's no extension of coverage in the event that there's a lawsuit resulting from professional liability services being rendered. That's what we're going to talk about next. So your professional liability insurance policy is different from your general liability policy in that it's protecting against a financial injury lawsuit to a third party. So we go away from the physical injury. Now somehow there's some allegation of a financial injury to a third party, which could, of course, be a client. It could even be a competitor, which many people are not aware of. But in particular, we're concerned with ensuring that there's professional liability insurance or errors and omissions insurance in the event that you're sued by a client. So a simple example of a claim that we see, and we'll examine some additional claims in a few minutes, is if in the event you fail to file on behalf of a client, missing the statute of limitations. We see that type of claim all the time here at Lawyer Cover. Okay, so many people feel that when they have to buy insurance, it's not necessarily the best news, and I recognize that that's generally because there's an expense associated with it. So I want to point out why it's actually great news. We talked about the importance of protecting your reputation and some level of protection to help avoid any major impact or business disruption. So why is professional liability insurance great news? Well, it simply means that you have clients, and that's a very positive thing, obviously. It means that you're making some money as a result of the services, the legal services you're providing to your clients, and presumably your business is growing and your reputation is important to you, and it's how you're generating the growth in your business. So isn't it time to protect all of this? Well, that's what we're here to help you do. I would like to give you the best possible framework to making sure that you're well positioned to succeed in obtaining the best possible coverage at the most competitive rates. It does take some work on your end, and the process starts with selecting the right insurance partner. Not enough attorneys spend enough time focused on interviewing potential partners to provide them with this type of coverage. And why is that important? You want to make sure that you select an insurance agent, an insurance partner that specializes in professional liability, and more importantly, specializes in insuring law firms against malpractice. Why is this important? Well, that specialist has a lot more leverage to negotiate on behalf of you to ensure that you're getting the best price, and more importantly, they have the knowledge to understand all of the different insurance policies available in the marketplace to help you, the buyer, make the most informed decision. And they should be making themselves available to you to demonstrate how much knowledge they have to ensure that they're asking the right questions about your practice to get you the best possible coverage. So let's look at now that you've evaluated your insurance partner. Presumably you have somebody that understands your business and it's time to apply for insurance. It's really important that your insurance agent understands exactly what it is that you specialize in. What are the areas of practice that you focus on as an attorney and as a law firm? You want to clearly identify those to your insurance agent so that they can help you apply for the most appropriate coverage. You also want to ensure that you're presenting yourself to the insurance underwriters in the most positive light. So highlighting your level of experience and those of the other attorneys at the firm is really critical. It's important to spend a significant amount of time, especially when you're obtaining your insurance for the first time, but also either after you may have had a change to your practice, added an additional attorney, or when an attorney leaves, or when you come up for renewal for your policy. Make sure that you spend some time to evaluate your current coverage, what it is you do, and making sure your insurance agent understands what changes may have taken place. This is really important, and it does lead to cost savings down the road. So now that you've evaluated your agent, you've applied for an insurance policy, what are some things that you should be aware of before you make your buying decision? You want to really understand what it is you're purchasing. I know that seems pretty basic, but I think it's a step that is missed often in the process. So you want to start with looking at the coverage that is being offered to you in the form of the insurance policy or the contract. So with any contract, you want to ensure that you evaluate it fully, paying close attention to the definitions in the policy, as well as what exclusions exist in the policy. The professional liability coverage contract is an all-perils policy. That means that everything is covered, everything is defined in the coverage, and anything that is not covered will be under the exclusions. So you want to really evaluate those. You want to ensure that if there's an exclusion in the policy, that it's not prohibitive to making sure that you have the right level of coverage. All of these policies are written in many different ways, so it's important to evaluate that. And a good specialist agent should help you understand that and navigate that process pretty effectively. So that's why it's so important to start with evaluating your agent, your partner. So if you're now comfortable that you have the right coverage, what are some of the added benefits? How else can you qualify the right insurance carrier for you and the right insurance coverage for you? Many insurance carriers will offer some additional enhanced coverage features to your insurance policy. They should be spelled out. You can ask for them, and then your insurance agent should be able to identify them. One great example of this, what type of risk management tools are provided? I'm going to spell out several, and certainly Lawyer Cover and Kevin McKernan will be able to help you with that as well. But ideally, you would have many different risk management tools at your disposal to make sure that you're avoiding claims. And why is that important? Well, the longer you avoid a malpractice claim, the more attractive you are and the better rates you're going to be able to obtain. Another important process to evaluate in selecting your insurance coverage is relative to claims. That's what the coverage is for. In the event that you have a claim, your insurance agent and insurance partner should be able to identify in the policy how you are to submit claims in the event that there's some allegation of negligence. It's typically spelled out in the policy clearly. In some instances, insurance carriers require that there be some demand for money in order for coverage to trigger. In some cases, you only need to be aware of a potential claim, and that should be something you should share with your agent and talk with the insurance carrier about. So there are important coverage distinctions. You want to figure out exactly how claims should be submitted, and obviously you want the most liberal claims clause available in the policy that you're selecting. Along the same lines, many insureds fail to recognize the importance of the claims adjusters in this process. A good insurance carrier will hire claims adjusters, in many cases, who are also attorneys themselves handling lawyers' malpractice coverage. Why is that important? Well, you're negotiating with your insurance carrier, and they are appointing a defense counsel on your behalf. You want to make sure that you have somebody in your corner that understands what you're going through and at that point, the point of a claim can really help you navigate that process at that time. So you want to see that there are really experienced claims adjusters that will be working on your behalf at this critical time during a claim. So now you have insurance. Where does this all lead to? Well, you're now carrying a professional liability policy with an insurance agent who understands your coverage and an insurance carrier that's in your corner to defend you in the event that there is some allegation of malpractice. The intent of this is to help you feel confident about doing your job and less focused about worrying about making a mistake and not having somebody there to help you through that process. So to give you some additional information about the types of claims that we see on a regular basis here at Lawyer Cover, I prepared some claims examples for you. I think you may find it interesting. The first one is an attorney was retained to pursue a client's third-party personal injury claim. However, the attorney failed to file the claim before the statute of limitation expired, which caused the claimant to lose his ability to pursue the cause of action. The client sued seeking damages of $150,000 to cover their ongoing medical expenses. Additionally, the attorney will incur defense costs in excess of $100,000. Many of you handle personal injury types of claims. This is a pretty high area of practice from a claims frequency standpoint, and as you can see in this case, the result would be nearly $250,000 in expenses and damages in the event that there's fault on behalf of the client. So having a policy there to defend yourself is really critical and obviously would protect your business. I think we have time for a second claim example. In this case, an attorney within a firm forged client signatures on settlement checks and deposited the funds into his personal account. Now, obviously, I recognize that nobody attending this webinar would get themselves into this situation, but I'll read on, and you'll see how it could still be important to have the right coverage in place under this type of scenario. The lawsuit ultimately filed by the damaged clients named the attorney that was at fault, as well as all partners of the firm. And remember, the firm can be sued itself, and in this case it was. So not only was the attorney that actually forged the checks, obviously they were sued, but the partners in the firm itself were sued. The ultimate defense costs paid out in this scenario exceeded $100,000. So again, even if you did nothing wrong, you could be named as a party to the lawsuit and would need an insurance partner in your back corner to help defend in that scenario. So let's talk about some other related types of professional liability coverages that you should be aware of. They're not direct malpractice claims, but more and more malpractice insurance carriers are providing for employment practices liability insurance. This is an extension of coverage in the event that you're sued by a fellow employee for some type of harassment or wrongful termination. Also, privacy is becoming a very important area of risk that you need to be aware of and evaluate whether or not your insurance policy provides some level of protection in the event that you lose some of your client's personal information, or in the event that your client's personal information that you're responsible for happens to be stolen. So looking at employment practices liability and privacy protection as an add-on to your malpractice coverage is becoming more and more common, and is something that you should evaluate with your insurance agent. So let's talk about helping you reduce your claims and help you pay lower premiums for your insurance. The following are steps to avoiding malpractice. In many cases, they're basic, but oftentimes taken for granted and overlooked. So the first one we note is staying organized. Staying organized is really important as a tool to help avoiding malpractice claims. In fact, according to the American Bar Association, one of the leading causes of legal malpractice claims is disorganization. This could lead to missing a deadline, double booking your calendar, or losing track of a case. Very important to stay organized. Next, communication is really key in helping avoiding any types of miscommunication or misunderstanding with your clients that could ultimately lead to some type of malpractice lawsuit. It's really important to communicate properly with your clients up front. 3 easy ways to alleviate a client's concerns and communicate effectively include things as simple as returning phone calls in a timely manner, explaining decisions that you made during the case, and listening to your client's needs and what their goals are. Also, managing client relationships is really key to helping to avoid malpractice lawsuits. Mistakes are inevitable, but a strong client relationship could be the difference between resolving the issue with your client or suffering through a malpractice suit. Also, avoiding conflicts of interest. Having a personal involvement with a client is generally never a good idea. You want to ensure both you and your fellow attorneys at the firm are evaluating any potential conflicts of interest that could lead to a malpractice claim. Some other areas to focus on involve avoiding fee disputes. Fee disputes tend to be the #1 cause that we see for malpractice lawsuits. So you want to make sure that up front, when you sit with your client, you're documenting the written agreement between you and your client, you're itemizing your bills when you're working on behalf of your client, and maintaining a detailed log. These are all good ways to avoid fee disputes and malpractice claims. Finally, it's really important that you avoid suing your clients for any unpaid fees. We see this all the time, and in almost every scenario, it tends to lead to some type of malpractice allegation when you sue your client for unpaid fees, because then they decide that all of a sudden you didn't perform your job professionally, and it gives them some reason not to have paid you. So avoiding fee disputes is really important, and avoiding suing your clients is also key. So for more tips to help you steer clear of professional liability suits, contact Kevin McKernan at lawyercover.com. So now we're at the point where we're evaluating coverage. The following are some areas that you should focus on. Your insurance agent should be able to explain the type of coverages afforded under your insurance policy. Crisis management. Crisis management is important and is typically a separate limit of liability. If you don't see it on your policy, you should be requesting it. The intent of that is to provide some type of public relations benefit in the event that you have an unanticipated departure of an entire practice group, or if there's the unfortunate departure, death, or disability of a managing partner or practice group head, or if there's the closing of the firm's principal office as a result of some type of damage as a result of fire or flood or natural disaster. These are really important tools that help you protect you and have little to no impact on your overall insurance damages, and tend to be provided without any deductible. Also, you want to ensure that as a fiduciary, the definition of wrongful acts includes the word fiduciary. In some cases, it does not. You want to have some rights over the settlement of your insurance policy, so you want to see a favorable consent to settle provision. And in the event that there is some type of professional services amongst insureds under the policy, that there's some level of protection in the insured versus insured exclusion. Some other things to look for: coverage for independent contractors if you have attorneys working from outside. You want to ensure that you have punitive damages coverage. It's not always insurable in all states, but you want to see that that's provided in your policy in the event that it is. And we talked about employment practices and privacy coverage, some additional coverage enhancements available to you. So let's recap the things that we discussed. Try to give you the roadmap to becoming the best possible insured, obtaining the most competitive pricing and favorable insurance policy. So we defined what professional liability is. We talked about why it's important that you purchase it. We talked a little bit about how the process works and tips for reducing claims and features to review before you purchase your insurance. So most importantly, the last thing you want to do is wait for the following to happen before you decide you have the right insurance coverage in place. This is a cartoon. The woman comes in and talks about how the attorney just lost a medical malpractice suit, and now the attorney is being sued for malpractice. So I want to thank you all for attending and for your time. And for more information, please contact Kevin McKernan. Also, be sure to look out for our email on more professional liability topics discussed on the Lawyer Cover blog and how to submit questions directly to Kevin. In addition, we'll be sending you a link to this presentation for further evaluation. Thank you so much.
Thanks, Brian. We're going to take a few minutes right now to do a Q&A, and while we're doing the Q&A, we'll also have a quick poll just asking the people who are in attendance today if they'd like more information from Lawyer Cover. So while that's up, feel free to select your choice. And with that, we'll take the first question that's come in from the audience. Brian, do you have any tips for screening clients up front to help avoid malpractice suits down the road?
Yeah, absolutely. I mean, you want to steer clear of any clients who seem agitated when you're meeting with them. If they've been turned down by other law firms, that's a sure sign that there may be something strange going on with a particular client. Those are examples of ways to avoid any type of client that is a malpractice suit just waiting to happen. Now, another question I see is, what should I do if I receive a demand? Or what if I'm concerned I may be sued? That's a really good question. It's important that at that point you talk with your insurance agent about what your concerns are, that with your insurance agent, you sit down and evaluate your insurance policy to see exactly what your insurance policy says you should do under this scenario, and that you present all of the facts as you know them clearly to your agent and to your insurance carrier. Even if you haven't been sued, but you may be concerned that something could lead to a malpractice claim, it's important to talk with your carrier at that point.
Great. Thanks so much, Brian. I see that we're at the 30-minute mark, which is where we would like to keep these. So we're going to go ahead and stop right there. We really appreciate everybody being here with us today. And we thank Lawyer Cover so much for presenting today's web seminar and for bringing us this important information to the legal community. And we look forward to seeing all of you to visit the Lawyer Cover blog for more information. And with that, we hope everyone has a wonderful afternoon.